late. All right. Cool.
No, let's wait for standing room only.
Standing room only?
Yeah.
Can a couple people in the back just stand so we can feel like we're SRO?
No, don't do that.
Yeah, you're the MVP. Woo! Woo! Awesome. All right, I'm gonna just kick us off, and when I get batteries, we'll do it in the middle of everything, so that'll be fun.
I'm gonna take your water.
Please don't. I need water.
I'm gonna take
And
your
water
water.
gives me life. And also it helps with that Thursday night hangover. Okay, so. Hello, everybody, and welcome to Intellectual Property in Odyssey.
Clapping for
So, first of all, there's a lot of you, which either means some of you are very lost, or all of you are, like all of us, nerds about law. If you are lost, please raise your hands.
It could be.
It will be eventually. Mainly. Actually, it might not because we're going to start. I thought this was beginning music theory. Yeah,
we're not qualified
You should
for
stay
it.
anyways, just in case. So what we're here today to talk about is Mickey Mouse for an hour. No, I'm kidding. And Disney comes in from the roof. Just anyways, so Steamboat Willie. So here's what we're here to talk about today. We're here to talk about some basics about intellectual property and also practical applications to the music and gaming industries. We are going to leave time for questions at the end, so make sure you do save your questions. If you're one of those people that gets up in the moment and you're like, oh crap, I forgot it, or you think that you might forget it over the course of the panel, write it down. We all have pocket computers at this point, so that should help a little bit. In addition, if you have a question or have something that we just don't touch on, we're happy to talk afterwards. They will kick us out of the room at some point, but we're happy to chat. One more thing, legal disclaimer, because this is an all-lawyer panel. What's up? All right, legal disclaimer. Everything that we're about to say on this panel is for general informational purposes only and is not construed as legal advice. We are not your lawyers, unless we literally are. I see a few of you out there, in which case, hi. But we are not your lawyers. This does not create an attorney-client relationship. We are available for hire in most cases, and we offer free consults for the most part as well. So feel free to contact us afterwards. What I'm trying to say here is, don't take this legal advice and try it at home. Go to a friend's house. Okay. So,
Also, just so you know, I see this gentleman recording here. You're very welcome to record. I believe they're also recording the panel and then they're going to post it online.
Yeah.
So you don't have to keep your hands up with your phone up if you don't want
get
to.
tired, we've got a backup. Yeah. And also, so first question for everybody, and then I'll let somebody else talk because I'm loud and don't have an active mic. I just realized that I'm the only one talking and I don't have a mic.
You don't need it.
That's
I mean, I gave you this one, but you're just like, you want to ignore it, so.
You got 2 double A's for me? Everybody clap for Dave.
Batteries.
So, who out here is a lawyer? All right, cool. All right, cool. If you hear any inaccuracies, please leave.
Don't say anything.
Or see me afterwards and we'll argue. Who out here is a game developer? Okay, we got a few. How many are musicians? How many are streamers? Cool. Who's just here because you really like to hear about the law?
Wow.
All right.
Wow.
That's awesome. This is MAGFest is cool. All right. So
One more category. Any engineers or inventors?
Yeah.
Nice.
Very cool.
Good call, Ben. Good call. All right, cool. So here's what we're gonna do. Hold on. Hello. Fantastic. That's going to help so much. I'm going to go down to the other end of the table and let people start introducing themselves by saying who they are, where they work, what they do, and what their favorite flavor of ice cream is. Not favorite type of estoppel. No. Your favorite rule against perpetuities. Anyways.
No.
Texas's form of rule against perpetuities. Anyway, my name is Ben Premack. I am the managing partner and co-founder of Premack Rogers PC. I also work with Tess and Noah and this gentleman down here in the green coat on the front row, Leo. And we offer legal services to people in all sorts of creative fields. So, the firm really started focusing on the video game industry specifically, but over the last years, it's grown to something where we help musicians, streamers, individual artists, tabletop creators, really anyone who is a creative making something to go out and put it into the field. So looking forward to all your questions, and thanks for coming.
My name is Jess Linton. I'm the legal counsel at Evolved Talent Agency, which is one of the premier talent agencies for esports athletes and content creators. We represent people like XQC, Germa, Amaranth, and I work mostly on the contracting side for their brand deals and any other legal needs that my talent may have.
My name is James Williams. I'm an attorney at Tingen Law, and our firm has been historically based in immigration, but through me and my managing partner, we're growing the business and intellectual property areas to work with creators and other types of business owners.
Hi, my name is Tess. I'm an associate at Premac Rogers with these nerds and that nerd, and I mostly specialize in privacy, but they've got me into IP recently, so now I'm an expert to talk on it, I guess.
And hi, my name's Noah Downs, aka my lawyer friend. I'm a lawyer, but I'm a cool lawyer, just like everybody else up here. And I'm gonna go ahead and soft launch it, guys. I'm a partner at Premac Rogers Downs PC as of January 1st.
Premac Rogers, now Premac Rogers Downs of about a week ago.
Yeah,
So
as about a
Last
week
name
ago.
edition.
congratulations, Noah.
We haven't updated the letterhead yet. I came up in the industry working with musicians and artists and content creators on Twitch and YouTube. I co-founded Pretzel Rocks, which is a Spotify-like music streaming services for streamers and YouTubers. And I co-founded a DMCA-safe music label called 99 Lives. We exited those successfully a couple of years ago, and since then I've been just cruising along, having a great time, representing content creators, tabletop creators, game developers, publishers, musicians, designers. Basically, if it's legal or illegal in the gaming industry, we got you. And so without further ado, can I say that?
Wait, don't you have a podcast, Noah?
Oh, I also have a podcast. I am a content
he
creator
forgot
myself.
about it.
I'm a Twitch partner, and I have an actual play podcast. It's a D&D podcast called Forgotten Paths. If you take nothing else away from this panel, make sure you download every episode. Don't care if you listen, just download it. It's fine. Okay. So, let's dive into it. So let's get a general overview of intellectual property. Real quick, by show of hands, who thinks they know what a copyright is? All right, the usual suspects. Great. Who thinks they know what a trademark is? Great. Who out here thought those two things were the same thing? The brave ones. Thank you so much. That means we're going to do something. We're also going to talk about patent law very briefly, as well as trade secret law and how you can protect those things too. But let's go ahead and take it away. Who wants to say, hey, what's a copyright, guys?
Hey, Tess, what's a copyright?
Oh, man. Well, as an artist and a writer, I should know what copyrights are, because the moment I make it, it's mine. You don't even have to register it, although it is better if you register it, because then if anyone makes, a similar thing and claims it as their own, and they register it before you, they technically can take it away. So that's a nutshell of what copyright is, but it applies to the art, music, and the written words of any project that you might be working on.
Yeah.
Did I nail it?
You nailed it. You crushed it. To put it in slightly more legalese terms, copyright is something that is any work of art or some type of expression that is fixed in a tangible medium of expression. So basically, if I draw a smiley face on a Post-it note, I might have copyright in that Post-it note smiley face.
It's going to be a really weak copyright.
Very weak copyright.
It's going to be a copyright.
That's because I'm not good at art. That's it, right?
No.
Okay.
It could be a really interesting smiley face.
It could be an amazing smiley face. So copyrights are different from trademarks. Ben, talk about trademarks.
Trademarks are, I'm going to dive right into more of the legal definition, which is trademarks are the indication of the source of a good or service. So whenever you guys see a brand name somewhere, Toyota, Coca-Cola, Gaylord National Hotel.
MAGFest.
Yep, MAGFest.
Yeah.
That is a trademark because that indicates who is actually providing that good, such as this water, or who is providing the service, such as providing us with a lovely place to hold MAGFest, or MAGFest itself to organize everything that we're doing here. So, how's that work for you, Noah?
That was phenomenal.
Nailed it.
So typically the difference between copyrights and trademarks, which two you want to describe what the difference is between the two?
Oh, then Rochambeau.
I believe in you.
Don't. I
Yeah.
was here to talk about licensing.
Licensing, that's right. Hey, take it away. You got it, James.
Okay, I'll do it.
I realized he didn't realize I was looking at
What
him.
did I just say?
On the spot, no. Okay, so there is definitely room for overlap. You can have something that is a logo or design that you could register both as a copyright as well as an indicator like the logo for MAGFest. But how you use them, frankly, is kind of the difference. So if you're trying to say this is who made the product, the good or the service, then that pushes you more in terms of trademark territory. And all of the trademark laws, there are differences in how you litigate these types of issues. Whereas, like, if you make T-shirts and you're not trying to say this T-shirt is made by the brand, but you just have a design, then it's what we call ornamental, just for design purposes. There are plenty of people who still try to register those as trademarks within the trademark database. There are plenty of T-shirt bots out there. If you have a brand, you've probably dealt with that online at some point or another. But we've got likelihood of confusion for trademarks. It's more of a business type of foundation, whereas copyright law, it comes down to substantial similarity, some legalese that we can get into if you want, but otherwise just comes down to how and why you're trying to use that content.
Nailed it. To put it more simply and actually talk a little bit more about the T-shirt example that James said, one of the most common things we get, as attorneys is somebody comes to us and says, hey, I've got this great lifestyle brand idea because it worked really well for Supreme. And so I want to be the next Supreme or Billabong or something like that. I put my brand name all over my shirts. I need to file a trademark. And I look at it and I say, well, the inside of the tag still says Fruit of the Loom. Fruit of the Loom in that case is a trademark use. If you have your brand name under the tag or it's the identifier of the source of that good or service, then that is a trademark use. Whereas just the image, the brand, like the logo, etc., that is copyright use, and it's an ornamental copyright use. Now, it gets really confusing, like when you put like a brand name in like the top left corner, like St. Jude, for example, which is an amazing organization that you should all support.
Hey, Noah. Maybe we should get off clothing because clothing is even complicated for lawyers to understand.
Yeah, I know.
So,
Yeah, that's fair. But basically, don't do it yourself.
yeah. So, to use kind of a more clear-cut example, something like a video game. Let's say Metroid Prime. The game itself is subject to copyright. Once that game, once Nintendo has finished making it, they publish it, it is a copyrighted thing. It cannot be then reproduced by anyone else, distributed, made. No one can make derivatives of it, anything like that. Whereas the name Metroid Prime is the trademark that's associated with that good. So it indicates to all of us that the game that we are about to buy is a Metroid game. So we've got the copyrighted use in the game itself, we've got the trademark of the name.
Nailed it. All right, cool. So we also kind of want to do a general quick overview of patent law and trade secret law. Who feels confident about patent? I think Ben was volunteering prior.
Sure, we can talk about patent real quick.
Yeah.
So patent rarely comes up in the creative maker space because it is really only for tangible inventions. About 15 years ago, it was possible to patent a lot more things, especially, you get into patenting code and stuff like that. That's all been stopped, largely because the patent database was getting far too crowded with duplicative patents. Essentially, they didn't understand the code well enough to distinguish between what they were actually giving people patents on. So probably the best known example, and the best example that I can give you of patent in this space, is of the D-pad. There's a reason why for years and years and years you only saw D-pads on Nintendo's controllers. And that was because Nintendo owned the patent to that design. You saw, close functional equivalents, but they were not the same thing, and that's because of patent. And so it's very rare that we as video game attorneys or attorneys representing creatives will have something where patent comes up. But every once in a while we do. We'll have someone come in and they've got a really interesting idea for a new controller. a new way to actually interface with the game that creates an actual invention, something that has never existed before, and then that is subject to that is potentially subject to patent, and so we'll help them to kind of go through the tree there, understand whether or not it's patentable, whether or not they want to go through the cost and the expense to do so, and then we'll walk them through it. So.
And just one thing I love about being at MAGFest, if you go into like the indie showcase area, we're talking about new types of controllers and what people do. Like, that's just one of the many opportunities that you get to see people taking that initiative and saying like, hey, what if a broom were a controller?
Yeah.
Or, anything like that, and then just trying to modify it. But generally, yeah.
Another reason that we typically don't recommend that clients go for patents, as kind of Ben was indicating, is I have the very practical experience of when I was a first-year attorney working at an intellectual property boutique. I worked for a managing partner at that time who really aggressively pursued patents for clients because they were very lucrative. And so we had a client that went and spent $60,000 securing a patent. And then within a week of securing it, the patent office rolled back the protections that we had been granted and made the entire thing useless. So we are hesitant to recommend patents unless there's a very specific circumstance. In general, we'll try and protect your intellectual property through traditional copyright, traditional trademark, your brand protection means, but also through trade secret, which, who's heard of trade secret? Raise your hands. Great, fantastic. It's not just what Chef Gordon Ramsay has when he's cooking that amazing food. Thank you.
You're welcome.
No, it's awesome. Trade secrets are a little bit more difficult to protect because once a trade secret is out, once it's publicly disseminated, or even really to anyone that's not under a contract with you, it can't put that cat back in the bag. Has anybody even tried to put a cat in a bag? It's a very difficult thing to do.
There we go. We got
Yeah,
some head nods.
the guy without the arms in the back. And so when it comes to trade secret, typically what we do is we protect those through non-disclosure agreements and confidentiality agreements because you're going to be sharing that trade secret with a limited scope, few people or employees or something like that. And you want to make sure that they don't lift what you have and share it with someone else because once it's out, and you really cannot put it back in absent amazing legal fees.
Hey, Noah, how would this apply in the game development context?
So, I'm glad you asked, Tess. So, for example, if you come up with a unique and inventive, that is a great question, actually. If you come up with a unique and inventive way of styling, God, what is it?
Here, I've got a good
Yeah,
one.
go for it. I'm about to say on the spot.
Yeah, so if you come up with a great way to to reduce the server lag between your game, Amazon Web Services, and you're able to significantly reduce your server load and how much time it actually takes to provide those services to your end user. And you're able to build that into your code so everything runs more efficiently. It's cheaper for you. It's faster for your user. It's also baked into your code. Keeping that secret is really the only way to protect it. If you start talking about it, if you put it up on GitHub, if you start going in and publicly disseminating that information, there's no way to protect it thereafter.
You lose your competitive advantage.
Exactly. So if you make innovations like that and build them into whatever you're doing, keep them secret. It's part of your competitive advantage. It's part of what's going to make it so that your venture is actually able to be profitable.
Now, when you're working with trade secrets and you're working with all the different types of IP that we've talked about up here, one of the number one things you're going to need to do when you're translating your work, now we move past the 101 stuff, guys. We're talking about the actual stuff now, so lean in. So once you are translating your work from something that you've ideated, something you've created, a brand, and you're starting to work with other people, you're starting to develop a product, develop a tabletop game, develop a video game, something like that, or you want to work with the individuals that do that, there's a specific way to do that. Well, there's a lot of different ways to do that, but one of the most common ways we do that is through licensing. So what we do is we license all of those things to other people. And hey, Jess, you want to talk a little bit about licensing?
Sure. So I'll approach it from a little bit of a different angle, but because I work with creators that are generally working with brands and creating content for them. Yep. So the brands would want to use their content in some advertising campaigns, whether that's paid or they're just cross-posting it or whatever they're doing. So generally what they'll ask to do is be able to use any content the creator creates during the course of the campaign, as well as their name, image, likeness, just kind of across the advertising campaign that they're planning. Obviously, this can get tricky in contracting because sometimes brands would like to use it in places that maybe your client doesn't necessarily want to see. Maybe they don't want to see their face plastered all over Twitter ads for some reason. So being able to put in those limitations for where you want your copyright, trademark, whatever IP we're talking about to be used by whoever you've decided to work with is particularly important.
It's all about controlling how what you do is used. And so when you work with licensing, just as Jess is saying, you're able to really put limits and create a contract with everyone you're working with. Now, a lot of you out there might be people that are saying, hey, I'm a content creator, like Jess is referring to. I'm a developer. I'm a tabletop game designer, something like that. I'm a musician. I'm just doing like a project in my basement with like 5 of my best buddies. Do I need contracts? Yeah, you do. Contracts save friendships. Let me repeat that. That's the most important thing you're going to hear all day. Contracts save friendships. It's amazing when everything is wonderful now and you're all, hunky-dory and you're like, hey, listen, we're going to take over the world. We're creating the next Mario. But now when money starts to come in, that's when Jim says, hey, listen, I think that I did more. And then Susan says, actually, no, I'm the one that created the company. And then Mark says, well, I funded everything. And then you've got a 3-way split, and your other 2 friends are just like, hey, I'm just here. And because you didn't have a contract, you're in trouble. So
Working in the corner.
like just the 2 people in the corner just like, guys, can we stop fighting?
There's a big bug, please.
Big bug, please. God. So let's talk about this in a little bit in the context to kind of pull along the thread of influencers and agencies and branding and deals like that. So when we're coming to specifically talk about influencers and streamers working with brands, as Jess indicated, those influencer streamers are going to want to license their name, image, and likeness. Now, what rights are kind of implicated by name, image, and likeness rights? Either Jess or Tess, one of the 2.
Who wants to talk about Vanna White?
Vanna White.
Do it, Jess.
Do it.
All right, this is reaching way back to law school. I believe that there was a case where was it a robot of Vanna White? Or like they used her in a commercial.
I believe it was Sony,
That was like a publicity rights.
and they created a fake robot.
A fake robot that was acting almost exactly like Vanna White, which Vanna White did not consent to.
Just a reminder to everyone, Vanna White was
The Wheel of Fortune.
Wheel of Fortune.
Wheel of
designer.
Fortune.
And so that was a huge case because that was kind of the first time that someone's image was being used in an ad campaign without their true consent. So would the company be able to draw upon any goodwill that Vanna White has with the American public in order to sell their products? The court said no, I believe. So
Yeah, they came down for Vanna White.
they came down for Vanna White and said the company was not allowed to do this. So that's something to consider too going forward. Companies can't just invoke a streamer's or content creators' fame or publicity in order to sell their product, promote their service, whatever they're doing without that creator's consent, typically in the form of a contract for some kind of compensation or benefit, which is what I do.
And to kind of follow up on that, that is something that's really come to light, especially recently in the world of deepfakes and AI, which you knew we were going to talk about it, right, guys? So because it is ever easier to create AI based on somebody's name, image, and likeness, their historical work, stuff like that, we have more than one celebrity literally rolling in their grave because their stuff is being used for basic interactions. However, what's interesting is because we have cases like that Vanna White case, we have more celebrities that are now able to work with AI companies to create interactive AI things to help them. For example, I think Evolve just closed one of these big deals, right? Amaranth?
Amaranths? We weren't directly involved with
That's
that.
fine.
We were consulting-ish on it. We knew some of the details, but Amaranth's special.
Yeah, Amaranth has basically released an AI chatbot where you can talk. They've trained it. You can talk with the AI as though you're talking to Amaranth, which is cool. I mean, there's definitely a wall there saying, "Hey, you're not talking to Amaranth, guys." By the way, but it allows some sort of like pseudo interaction with that parent-social relationship, which we're all terrified of as Twitch partners. So.
And more AI companies are definitely starting to go down that rabbit hole as well.
Yeah.
We have been in talks with several of them. They're definitely looking to kind of search that domain and see what kinds of people would be interested in either creating the AI or potentially interacting with the AI.
I've noticed a really interesting use case with video game developers lately and how they're using generated AI voices for their NPCs. And it's come up with a couple of interesting like tangents in this area because there are instances where they're reaching out to professional voice actors and asking to professionally clone their voice. And you've got to ask yourself, what does that mean? What is the scope of that contract that's supposed to save your friendship entail? Is it just limited to the one game that they make? Is it all DLC content? Is it for the sequel or the next iteration of it? And it's kind of important as a celebrity voice actor, streamer, that you minimize the amount that you have people using your likeness or publicity rights.
And so if you're a content creator or voice actor or someone that's a creative out there that you make a living off of your name, image, and likeness, now the contracts that you sign have a different element to them. They might even have the same language in them where you're licensing the content you make and it's owned by a third party at that point. You are assigning it. Instead of a license, you're giving ownership to a third party. Where if that third party owns that vocal track, potentially they could use it to train things unless you have a contract saying otherwise, which is a problem. And it's kind of a challenge for us lawyers to keep up with it.
And it's a problem when it's done wrong. I
it
think
usually
an
is.
excellent example of it being done right, and this hasn't been the subject of a lawsuit because everyone did it voluntarily and intentionally, was Majel Barrett helping to record her voice so that it could continue to be used as the voice of the computer in Star Trek, even after she passed away and was no longer able to do it herself. And
That's cool. I didn't know
yeah,
that happened.
I mean, they had so much recording of her from decades upon decades of her performing this role that then when she was getting ready to retire and be done doing the role, essentially she sat down and went, okay, well, let's record everything that you guys could need so that we could continue using this voice.
Cool.
And they did it with, it's contracts don't just save friendships, they also preserve relationships after death. So, yeah.
Contracts preserve relationships after death.
Wait, now I have a better one. Contracts, the path to immortality.
Contracts can make you immortal. Contact your local demon today and become a warlock. Thank you. I'll be outside. Mizora? Anyway, so another thing that we're commonly seeing right now is one of the most common aspects of how IP comes into play in our daily jobs is when we're working with game developers, designers, musicians, and content creators, people who want to create something together. Because as a musician, you want to own your works, right? Who in here is a musician again, by show of hands again? Cool. You want to own the works you make. It's cool to be hired. It's cool to have your stuff in a video game. But at the end of the day, you're doing it for a living. If you're an artist or you're a game designer or something like that, you want to make sure that you're owning everything you're doing. So what are some of the key clauses and language that we see in contracts? What are some big red flags we look for when we're generally reviewing a publishing or development or agreement or something like that?
From the musician side,
From any content creator side, just general.
who would like to take this? I talk a lot.
I'll take it.
Noah and I talk a lot. Jess?
I mean, I see this in the influencer space
Yeah, go for it.
too, because a lot of times, obviously, if you're doing an advertisement we can just meme on it and do Raid Shadow Legends.
Shadow Legends.
This isn't the case with Raid Shadow Legends necessarily, but as an example, a lot of some companies will try to assert ownership over the content created for the advertisement. So if a YouTuber is recording a 60-second ad that would go at the front of their video, I have seen companies attempt to assert ownership over that content and therefore any associated rights that come with it. Generally, I don't allow that.
What kind of rights?
The right to basically use it wherever they would want to. So if they wanted to take that 60-second spot, if they owned it and use it as a Twitter ad or on Facebook or something like that, they would have the right to do so if they owned it, with some caveats, but they would generally have more rights than I would prefer. So generally what we have to do is limit that usage to they would own anything they provided the creator. Obviously, the creator doesn't get to own the logo for Raid Shadow Legends. Right. They would still get ownership over that, but anything that the creator creates for the purposes of the partnership would still be owned by the creator and could be used for their purposes however they wanted.
Exactly. And one of the most common things that I know, I've seen some of the contracts that Jess has seen too, and one of the things that we look for is works made for hire,
Yep.
assignment languages, stuff like that transfers ownership of the content made to the end in person. So for example, if you are the video game publisher and you are trying to get a hold of some IP and you want to make a game from it, then you want to own the work generally, or you're trying to acquire it. If you are the designer, the IP holder, you want to license it so that you can license it to others, because whoever owns the IP, the intellectual property, which as we mentioned is an Odyssey, whoever owns the IP has a lot of rights. They can license it for the making of a film, or a TV series, and maybe a hit TV series, such as The Last of Us. They can license it all sorts of different adaptations. They can make sequels, prequels. They can work with other people. They can hire third parties, etc. Whoever owns the rights in the intellectual property, the copyrights and the trademarks, gets to do what they want with it.
I have a hypothetical question for you, Noah.
Go for it.
So what if I'm a really good intentioned developer? I made this game with all my friends, mostly handshake deals. I told them like, hey, we see some profits, you see some profits, but no contracts.
It's bad.
Let's say let's do another twist. Let's say I had a falling out with one of my lead artists for the games.
Uh-huh.
I've already launched.
That's real bad. This actually happened to one of my clients before they were my client. They became my client because of this. But one of the clients that I worked with actually worked with somebody that they didn't have contracts for. So this person created 197 minutes of music for a game. Yeah, let that sink in. And they were paid $50,000. My client, before they met me, did not have competent legal advice. They didn't have a lawyer, period. They worked with LegalZoom. LegalZoom was their lawyer. And they went to market. They were about to launch, and this musician came to them and said, hey, I talked to my lawyer, and I actually own all of this because I created it. The copyright is with me because I am the author of these works. I didn't have anything in writing with you, and therefore I want more money if you're going to continue to use it. If you do want paperwork with me, then you're going to need to pay me more. My client had to pull all the music from the game and ended up paying another $50,000 because the alternative was launching a game or delaying a game without music, and the music was an intrinsic part of the game because guess what? It was a rhythm game. So
let me give you a TLDR on that. So if you're on the company side, if you're making a video game, if you're publishing, if you're acting as a label for artists, what you want to have is you want to own the intellectual property. So what you want to see in your contract is something called a work for hire clause. That's what Noah was referring to earlier, where the work that is made is owned by your company. If you're on the individual creator side, it's the exact opposite. What you want to see is clauses that say that you own the work and then are licensing it to whoever has hired you in order to create it. There is no middle ground between those, unfortunately, and so it turns into a difficult negotiation point often if both sides are sophisticated. But it's something to be aware of. If you see in a contract, if you're an individual creator and you see in that contract work made for hire, that is a big flag for you that you need to talk with an attorney to make sure that you are not giving away more than you intended to. If you're on the company side and you don't see an assignment or you don't see work for hire in there, fire your attorney and get a better one.
And two other things just related to music as well as related to contracts. Noah and I had a conversation recently where I was talking to a creator who was working with a brand and was making designs. And so their question to me was, hey, this doesn't mention IP rights, so any assignment doesn't transfer ownership, does it? And a provision basically said, I give all rights, title, and interest. And so the TLDR is, it may or may not actually include copyright, but to figure it out, you just have to litigate it unless you get something in writing that verifies it. And so sometimes you might have a slight leg up and say, ha, gotcha. But then to enforce it, you have to litigate, which means you got to hire an attorney, you got to have something to pay for it, and then some way to kind of follow through. And not always a great answer, but another great reason to make sure everything is as specific as you can make it on the front side, but also the details are clear. And just another thing about music, pop culture reference, Taylor Swift.
Where are you going with this?
Okay.
That easy.
So Taylor's version. If you've been following Taylor's version and the whole kind of conversation about re-recording, that's another clause that's going to come up specifically from musicians. Typically, when you're talking about who owns the rights to music, you're going to have the musician who's going to have the composition. They write out the music, and then from there, it's going to come down to who's recording it. And so the recording rights are separate. If you go to a label, then they're going to want to own the recording rights. You might have a license, it varies from label to label, but if you're thinking greasy music industry people, then they're probably going to have more rights. But one of the problems that bigger artists like Taylor were dealing with is they would say, hey, look, we own these rights, and we'll have a license, but you can't re-record, and it's most likely going to be perpetual. So you would just want to be careful about anything that says perpetual. Anytime we talk about that, whether it's name, image, and likeness rights, or any of those types of rights, you want to make sure that you mitigate that. But Taylor Swift has the resources to enforce this, to try to change the scene, and a lot of other people don't.
Yeah.
So all the more reason to try to either cut that on the creator side or to just narrow it as much as you can, because that's your income, that's your life.
Yeah, and one of the things that I think we're going to start seeing for a lot of musicians coming forward pretty soon is because we have the re-releases of Taylor's work and a few other artists that have followed suit, we have a lot more record labels and people that are working and managers that are working with these artists that are saying, okay, you're going to retain rights to your underlying composition, but we're going to get an exclusive perpetual license. An exclusive means that, if that were the case for Taylor, Taylor would not be able to re-record it because it's exclusively licensed to the recording artist in that case. One of the things that James just brought up really actually stirred something that we haven't talked about, that I want to kind of get a feel for in the room. So everybody get your raising hands ready. So who in this room thinks that fair use is a good thing? Go. Just go. Fair use is bullshit.
Okay.
Give him some context.
Yeah.
Yeah.
So
Hey, Noah.
yeah.
What do you mean a good thing? I'm going to lawyer you here.
Yeah. So
Define
who
good.
thinks that fair use is something that you can easily use and or will help you if you
Okay,
use
there
somebody
we go.
else's
That
copyright
makes
work?
way more sense.
Yeah. Yeah, no,
Yeah.
I actually hate the concept of fair use as a whole, honestly. No, I'm kidding. I just hate how it's currently expressed because it really is bullshit. The way that fair use is currently out there, and for those of you who don't know, fair use is, without going into the exact 4-factor test, because I'm not ready to do that right now, I need more coffee. Fair use is the idea that you can use a portion or some other amount of substantiality of a copyrighted work without getting an appropriate license for it, because it is a fair use of that. You don't need to go and get an express license for it or even an implied license. Hey, I can use this part of a song. It's cool. It's just going to open my podcast. It's great. It's wonderful. That's bullshit. And the reason is that fair use is a defense, and you have to be sued generally in order to claim it, or you have to be in a litigation position. It's something that YouTube has said, hey, when you're doing takedowns and DMCA's and claiming works, you have to consider fair use. But most copyright holders say, oh yeah, I considered it, and I think it's bullshit. And so I will tell you that most people in the world do not have the funds to make a fair use defense. Because fair use is such a gray area that when you get to court, you're going to be much better off settling because your downside is going to be much, much, much bigger.
And if you are considering fair use, double check. Are you a professor at a higher institution of learning, or do you work for a newspaper? Otherwise, don't think about using fair use.
Yeah. Content creators, sorry, you don't get fair use unless you were like CoffeeZilla. So, and if you know who CoffeeZilla is, good for you because that's great content. So,
we got about 20 minutes. Do we want to go ahead and open
I was
up
about
the
to say, let's toss it on over to questions. I've got a mic here. Oh God, Sam's raising his hand. I've got a mic here for people. If you have questions, line up on this side here. I'm going to hand the first person to get up here this mic.
Yeah.
That's Sam. Sam Castro, everybody.
So I have
Easy questions only, please, Sam.
oh, forget it.
Okay.
I do have a question on your rhythm game
Yeah.
example, story, what
Oh,
have
boy.
you. So you said the composer had already been paid $50,000 to compose the work for. Was there any, and obviously don't breach privilege or anything, was there any discussion of an implied license to what that $50,000 actually bought the game developer?
Yep, there definitely was. Great question. So just to kind of repeat as well, just give it to the next person. On the example I provided earlier, where my client had hired a composer and recording artist to create $50,000 worth of work for 197 minutes worth of work, was there any discussion of an implied license? Now, an implied license is, hey, we don't have a writing. I haven't given you anything express that says, hey, yeah, you got the license or you own this, but it's implied because of our actions, right? And here's the thing about implied licensing is just that. It's a temporary license. It's not written, which means that it doesn't have really defined terms. And so we did consider it. However, one of the keys that you can turn for licenses is whether it's revocable or irrevocable. And so that means, can you revoke the license or can you not revoke the license? And without any writing, you could say that it's a revocable implied license, even if you did have an implied license, meaning that composer could say, actually, yeah, sure, you had an implied license. It's now revoked. So, great question, Sam. Thank you. Go ahead.
Yeah, I've seen a lot of cases where people have an idea for something and they kind of come in and they feel like they're owed something because they had this idea. Can you address kind of the legal ownership of these ideas?
Who wants to take it? Are you staring at me?
I'm staring down the table. You're at the end of it.
So I can give you an example. I was recently on the phone with Doug Riley. He's the legal, the head of legal over at Lucasfilm Video Games, Lucasfilm Interactive. And whenever Lucasfilm receives unsolicited storylines, unsolicited feedback, anything like that, they throw it in the trash. It is something where they don't even want to risk the chance that someone is going to come in and try to claim that they own some component, some storyline, some character, anything in anything that Lucasfilm is making. And so it's one where it is an unsettled area of the law because, like we were talking about earlier with copyright doesn't actually exist until something is set into a tangible medium. So if you're just talking about a story, that's not a copyrighted thing yet. But it's also one where litigating whether or not there's an issue there is very expensive for everyone. So it's just kind of a bad idea. Yeah.
Jon Snow.
Close. Zach Noah.
Oh, cool. Nice. Great. I was about to say, it's one of them.
You knocked that out. I was going to say that when I put this up.
Yeah,
You
yeah.
solved that for me.
Yep.
So I'm curious if establishing copyright for things like webcomics is any different from doing it for the same with books or other publications.
It's all the same because it's fixed in a tangible medium of expression. The question becomes if it's something that's transient. For example, a live stream on Twitch that is not recorded to a backup or something like that exists only in the moment, and once the VOD is gone, it's gone. Or there's no VOD, or video on demand, sorry, for everybody that's not familiar with the lingo. For example, if it is just gone immediately, did it ever fix? Is there copyright that attaches to that kind of thing? The answer, my stance on it personally, is that once it's fixed, if it goes somewhere, there's a copyright attached to it. And so that is where we typically run into problems in with the music industry on Twitch, because the use of music in the background of streams that isn't licensed, it's a copyright infringement, even though the artist will say, or the streamer will say, it's not because I didn't save it. So.
Thank you.
Yeah, thank you.
So you said fair use is generally just something you can do in a litigation, so it doesn't work to protect you when you do something unless you're getting sued. How does that work with generative AI? That is,
Not me. I've got strong feelings.
I mean,
I guess I'll
start.
Yeah.
I'll start this one. So, like, we talked about licensing, we talked about ownership, and have you followed any of the litigation, like with ChatGPT or Midjourney?
not too much. Mostly the artists complaining about their stuff getting taken.
Okay, so judges are not, for the most part, technical experts. So they're not engineers, they're not other people, which means that they rely on experts to be called in and kind of figure out, okay, how does this work? And that's important because if you see a really wacky decision, you're like, that's not how, this industry works. It's probably based, in litigation, the facts that were presented, all of that. But with generative AI, like with Zarya of the Dawn, one of the cases where they're trying to figure out, okay, does copy...
The comic book that was made
The comic book
out of generative AI?
that uses Midjourney.
Oh.
So the Copyright Office ended up saying, hey, look, no copyright for you for the portions that were created with Midjourney because, based in their opinion at the time, there wasn't selection, control, something from the creator that the human. That's very important. There wasn't control and selection from the human. And so like you go into Midjourney, the Discord, and you'll get like 4 automated images and generate it, right? And so what they're saying is you're not really shaping that content. You can make an argument and say, look, I selected it, I gave it instructions, I gave it a prompt. And right now, that's still muddy. The Copyright Office has issued a little bit more guidance on AI, but until we get some more litigation, more conversation with the Copyright Office, it's going to vary, and it's going to come down to which AI and how the AI creates those images. Yeah. I mean, all the litigation that we're seeing is also trying to figure out how you can prove that your art was actually used in like book 1, 2, or 3, which includes a lot of content for like the ChatGPT lawsuits. And so if you can't say to a judge, yes, this is substantially similar to my drawing or my art style, whatever is actually protected, then you're going to have a really bad time in litigation, which is why everything is so complicated.
And kind of pulling it back into fair use, it also depends on what you're doing with the AI, the generative AI. Are you just futzing around in your basement and never going to publicly release it, never going to commercially release it? Then you're not going to run into needing to make a fair use argument. But if you try to commercially exploit it, then broadly speaking, fair use only protects non-commercial uses. So it's not going to help you.
If you're interested in learning more about this topic, I'd look into what Adobe's trying to do with Firefly, because I know this isn't directly related to fair use, but I think the heart of your question is about AI and whether or not there's a copyright interest in it. And the courts so far have said no copyright interest, right? Anything you make with AI, doesn't belong to anyone. It is just out there in the ether of public domain, and anyone else can use it and exploit it as they want to. Adobe took this concept, and they're trying to train their machine learning data set only on public domain images, which they're hoping is going to get them out of the infringement territory that all the other generative AI companies are in.
And now it includes Steamboat Willie, so it's really fun.
We weren't going to talk about Mickey.
I mean, it's not just public domain. It's the fact that they have millions that they already own.
It's not just public domain, it's also stock footage, which I think is kind of sus, right? Because definitely the license did not anticipate this being included in a machine learning database.
So yeah,
And that's on that kind of note, just to kind of round it out and let us all kind of talk about it. The at its core, images made using AI that has been trained on the internet as a whole are infringing. They are. There's no way around it. Maybe that's my professional opinion. Somebody might disagree, but that's how I view it. It's infringing. It's based on existing works. It doesn't exist unless other works exist. Therefore, it's a derivative. Now, the question becomes, can you train an AI? Thank you, 10 minutes left. Can you train an AI to do something that would have a de minimis or a minimal amount of things taken? Right now, we're seeing watermarks showing up in this kind of AI, which is insane. And so I would say that right now, that technology does not exist, and the experts to weigh in on it at the court level that we're seeing in courts also do not exist. And so right now it is truly a, holy crap, we might have jumped ahead of our bootstraps kind of thing, which is fun because I love the John Oliver marrying a cabbage Mid-Journey images as much as anybody else. But at the same time, it's also a little concerning for our field in particular and for the artists that we represent and the people that want to make things using their art, because they're inherently put against each other because one thinks, oh, God, this is a cool tool, and the other one's seeing, oh, God, all my stuff's being ripped off, that kind of stuff. So great question.
And with the AI stuff, ChatGPT, OpenAI, the owners have that lawsuit with New York Times right now.
Yeah.
And they've basically made a public fair use defense. So, like, I'm going to watch it.
Yeah.
Keep an eye out.
We're following closely. So go ahead.
One of the other things you mentioned in the description is like tabletop RPGs. And one of the things that's grown as an area to produce material are community content programs, where a licensor says, hey, you can use my world and come up with your own thing. But everyone seems to have a different agreement, a different notion of profit share, a different notion of what you're getting and what you're handing over. For the public who just wants to write an interesting story in a game world I love, what should we be looking for when we look through that agreement? Has there been any interesting litigation or cases where someone got screwed, or alternatively a firm wrote an agreement that was terrible? Has anything happened in that community content space?
If you want to look at an agreement that was terrible, how about the proposed changes to the OGL last January? And you want to look how terrible it was, Hasbro's stock dropped by 7% because they messed up so bad.
Yeah, it did.
So, so I would say that you should look for licensing that is open. Candidly, now that we have OGL 1.0A, because we beat WotC, which was dope. Well, now we have OGL 1.0A as canon, and we also have the 5e SRD in the Creative Commons license. For those of you who don't do tabletop, this is all just gibberish, and I'm so sorry, so I'll be very quick. But for those of you who are following along there, because we have the 5e SRD in both Creative Commons and under the OGL, it's fairly safe now. But however, you look at these other worlds that have come up under the ORC license. The ORC license was fantastic. Our firm actually consulted on the ORC license with Paizo and Paizo's counsel. It's good because it allows for downstream creative development while retaining certain aspects of ownership. It allows the creator of a work to retain what they want to retain, and then allows others to play in that sandbox too. So it's basically saying, hey, I have this pterodactyl, that's my pterodactyl, but you can play in the rest of the sandbox, that kind of thing. However, I will note that some of your favorite shows out there have very restrictive fan content licenses. And that is not necessarily a bad thing. It's just a choice that they made. So you've got to be very careful. For example, if you're looking at Critical Role content, their fan content licenses are super restrictive. And like I said, that's not a bad thing. That's not a criticism of Critical Role. What it is they have their sandbox, and they only allow a few people to play in it because they've successfully been licensing it to Wizards of the Coast to sell, which is great for them. So that's kind of where it is. Look for people that allow you to play in their sandboxes, and then you can have fun there.
Yeah, and it also ties into, we were doing a panel yesterday about music licensing, and we talked a little bit about Creative Commons, and this all ties together. Take a look at the license of the content that you want to use.
Yeah.
Look at it closely, see what it says. If the wording is confusing, talk with a lawyer. If it's pretty clear and you feel comfortable, going with it, have some fun. But most people are okay with you playing in their sandbox. They just want to make sure that they retain some control over it.
Yeah, and just to kind of chime in real quick, for those of you who are following along at home with D&D content, I am creating a Kinku Bard because it's going to be so much fun for copyright infringement. Okay.
Control F perpetual in all
Yes.
licenses.
Yeah, exactly.
It is my least favorite word. Ever.
Go ahead, friend.
So in the
Nice
community-run tournament scene, we see a lot of companies sending cease and desists to tournament organizers. And a lot of people who aren't lawyers online have strong feelings about that. And nothing I've found has been really clear about what it is. So I was wondering, is there clear precedent or settled law around this? Or is it a case of going up against Nintendo lawyers is terrifying and expensive?
Yeah, you guys mind if I chime in on this one again? So unfortunately, in the sports that we play nowadays, so like esports, we don't own those anymore. We don't have the right to say, hey, this is out there. So, yeah, Overwatch League, Blizzard has the right to shut that down. Riot has the right to shut down and limit what licenses they're granting licenses for, or tournaments they're granting licenses for. We no longer own the sports that we're playing online. It used to be like, hey, I can create my own baseball league because nobody owns baseball. Nobody owns the rules of baseball. You can just go out, find a sandlot, knock around a few balls, jump over a neighbor's fence, grab a run from a dog. It's a Sandlot reference, guys. But unfortunately, you don't have that with Blizzard. You don't have that with WoW. You don't have that with any of those. So these unlicensed tournaments, unfortunately, are shut down because we also don't own the games we play anymore. We receive a license to them. You might get a physical copy, but you're not buying a game. You're buying something that'll download the game. And that can be revoked at any time. So they can shut them down, but it sucks.
Yeah, so let's kind of pull that apart into components and talk a little bit about the trademarks and the copyrights that are associated with that real quick. So let's say someone wanted to run a Magic the Gathering tournament, and they didn't have a license to do so. Who can think of a problem with that?
They don't have a license to run the Magic the Gathering tournament? Well,
Yeah.
it could get shut down. We could start
Right.
there.
So is there a trademark issue associated with that?
Sure. Yeah, the Magic the Gathering is owned by Wizards of the Coast, so that would be subject to the trademark DMCA shutdown.
Yeah. So what about the rule books are copyrighted by Hasbro, and they're needing to you have those rule books at the tournament and disseminating them, possibly putting them up on the wall and publicly displaying them. That's a copyright issue. So there are a whole bunch of areas here where an unlicensed tournament, especially one where there's people being charged to participate in that tournament, where you are creating definite infringement issues. And so yeah,
You'd have copyright issues with merch too, right?
What was that?
Yeah,
Yes.
Oh, yeah.
Merch.
And trademarks. All right, cool. And last, but certainly not least, how are you doing?
Hey, pretty good. I'm up here again. So I created a game with some friends, right? And it was a TTRPG. We made our own dice system and everything. How do we start making sure that we have these copyrights in place?
Take
and
one of our
stuff?
cards.
Get a
And
lawyer.
what do we?
Get a lawyer.
Well, what should we also watch out for in a lawyer? Like, what do we want to see?
Most lawyers will give you free consults. Always talk to a lawyer about fees and rates and stuff like that. Make sure you establish that up front. Most lawyers will say they work in very different fee areas. Typically, when you're an indie, you need somebody that's experienced with indies.
Yeah.
And because they will help you grow because they've helped people from the beginning to the end. But yeah, in general, talk to a lawyer, but also contracts save friendships. So, I don't recommend LegalZoom ever. LegalZoom is wonderful for us as attorneys because you could either pay us to do it or you can pay us to fix it when LegalZoom messes it up, and then you're just paying double. So, yeah, LegalZoom, I said it, sue me.
Well, and to add a little bit onto that answer as well, so the five of us up here and the other lawyers in the audience, we're all licensed and technically able to go out and do family law, criminal law, any sort of legal practice that might come across our desks. We've all chosen to highly specialize into assisting creative people with dealing with their problems and knowing how to fix them, and how to avoid having what they want to do with their businesses or what they want to do with their lives become problems in the first place. It's one of my favorite things to do. So look for a lawyer who knows about working with creative folk. Don't go out and expect a traffic lawyer to be able to help you with, or even a general contracts lawyer to be able to help you with the sort of IP issues that come up in this industry.
Awesome. Thank you so much. You've been wonderful.